Welcome to another episode of The Breakdown. See, the thing that I love about doing this show is that we don't pretend to be that smart. We don't, because we know we're not. There's some things that we know a little bit about, there's some things that we don't. But when we don't know the things, that's where we reach out to people who do know the things. And it's been the legislature came back at the end of October, and it has been a dynamic and exciting, if not somewhat controversial, period of time with a boatload of legislation that has a boatload of implications being introduced in order to make sense of the legal ramifications of this legislation, the potential legal ramifications, I probably should say. I am so excited to welcome back to the show somebody who's been on the show a couple of times, and she's absolutely fantastic. She's an assistant professor in the Faculty of Law at the University of Calgary. She has a joint appointment to the Department of Community Health Sciences in the Cummings School of Medicine. And she does a bunch of other things. And she's taking on a new venture currently as well. Because when you have all of those things, why not do one more thing? Very excited to welcome back to the program Dr. Lorian Hardcastle. Dr. Hardcastle, thank you so much for taking the time to sit down with us today.
Thank you for having me.
So hey, boring time in politics, right?
It's been a week, a busy week. I think we all knew that when they came back there would be new legislation, but they really went off with a bang.
They swung for the cheap seats, that's for sure. We got four things, four and a half, I'll say, that I want to pick your brain about, because there is already legal action that is being prepared against some of these things, but there's some other things that are going on as well. So today I want to talk about the Bill of Rights. I want to talk about Bill 26, the Health Statutes Amendment Act. I want to talk about Bill 27, the Education Amendment Act, and Bill 29, the Fairness and Safety in Sport Act. And if you can't, for the audio listeners, pick up on my derision, particularly for the last one, I promise you it is real. But let's start with the Bill of Rights piece, because there's some implications. You're mentioning sort of in the pre-interview, there's some implications for some of the pieces of the Bill of Rights for larger things. And there's more than one Bill of Rights that we have to talk about, which is perfectly normal for the province of Alberta, I suppose. But let's start with what the government introduced. So what are your takeaways what are the things that struck you from the official legislation that the government introduced?
Sure. So I think that it creates new rights around freedom from vaccination, freedom from coercive medical treatment. I think those are interesting new rights that I think we definitely have to get into. It also talks about having firearms rights, although the language that's used is firearms rights, as guaranteed by existing laws. And then, those are two big things. And then it also talks about property rights. So the right not to have your property taken without compensation. And then as we see with the charter, there's a limitations clause that subjects all of those rights to reasonable limits that are demonstrably justified in a free and democratic, instead of society like the charter, it says a free and democratic Alberta. So perhaps invites the courts to come up with an Alberta specific version of what reasonable limits look like. And then it also talks a little bit about the kinds of remedies that are available for violations of the Bill of Rights, and specifically monetary compensation isn't available. And then similar to sections 32 and 33 of the Charter, the Bill of Rights talks about who it applies to, and then it has its own version of the notwithstanding clause where the government can keep legislation in place despite the fact that it is found to limit individual rights.
Wow, you gave me so much to unpack there.
Mhm.
I'm gonna do my best to go in a little bit of order. The vaccination piece is fascinating to me because there's a particular word that they threw in there. I believe it's either competency or capacity. And that's obviously foreshadowing another piece of legislation that we haven't seen yet. But I guess the question that I have with that is the mechanisms to determine competency and capacity are not just, oh, I don't like your decisions. They are time dependent to some degree, like officer of the law or a emergency room physician can remove somebody's ability to make decisions for a short period of time, but for an extended period of time, that requires more people with more letters behind their names. What do you make of the that competency? And like, here's the question that I'm trying to get to. Are we going to have to do competency and capacity assessments on every single person who says, I would like not to get the vaccine?
Yeah, so I think the capacity wording is meant to capture a couple things. One, it's meant to capture situations of things like children, where of course parents make vaccine decisions on behalf of their children, and that happens all the time. And we don't have an age for medical consent in the province, but rather there are children who are 13, 14, 15, et cetera, who might themselves meet the test for capacity and get to make medical decisions on their own behalf. So it captures that. The other thing that the provisions around medical coercion, I think, are carving out an exception for, and not just vaccines, but the more general right to be free from medical coercion, is the government's forthcoming compassionate care legislation that will allow them to compel treatment for individuals who are suffering with addiction. And then the other thing is existing mental health laws that in Alberta do allow for individuals to be treated even where they might not consent to that treatment. And that mental health legislation, I think people probably forget, but that mental health legislation was itself the subject of a charter challenge just a couple of years ago, and the court came down quite hard on both the treatment of the individual in that case, but also the legislation itself. And the judge said that legislation violated the charter in a number of ways. So I think we might see interesting litigation in the future where the provisions of the Mental Health Act and potentially the provisions of the new Compassionate Care Act, we could see litigation where people allege that those pieces of legislation are contrary to not only the charter, but the government's own Bill of Rights. And it'll be up to a court to unpack, is this coercive? Does this legislation meet the bar set out in the Bill of Rights? And then, of course, are any limits on individual rights and freedoms justified?
There's a fascinating little component here that I find I'm doing a little bit of foreshadowing, but
Yeah.
if the argument is there are kids who can't make the decisions about vaccines, therefore it's up to their parents. Um, and I want to be clear here, I'm not leaning into the anti-vax rhetoric. That being said, there are side effects that can occur with vaccines. They are proven, they're demonstrable. They are also exceptionally rare. So everybody should go and get vaccinated, unless your doctor tells you not to. Talk to your doctor. That's the smartest thing to do. But the reality is that any medical procedure, any medical intervention carries with it risk. I find it fascinating, especially given what we're going to be talking about later, that in this piece of legislation, the provincial government is saying, "Hey, you know what? Sometimes kids, they can't make all the decisions, so we have to get the parents to make those decisions, even if they have potentially life-altering and or life-threatening consequences. Parents can make those decisions." Um, am I getting that wrong?
No, no. So the way it works, Alberta doesn't have an age of capacity, and so there are either the minor themselves can make decisions depending if they have the ability to understand the medical treatment, its risks, its consequences, and if not, generally speaking, the parent or the guardian is the one who gets to make those decisions on their behalf. And so there's a whole bunch of case law where the courts talk about how parents generally know what's in your best interest. Parents understand the child best, understand sort of the context of their life the best. And really, only in extreme cases will courts get involved. And so the kind of classic example is a child whose parents are Jehovah's Witnesses and refuse a blood transfusion on their behalf. We have seen in those cases the very temporary involvement of social services just to deal with that issue. But generally speaking, the courts have said that parents have the ability to make life-altering, significant decisions. In some cases, to terminate life support, where it seems clear that the child isn't going to benefit from further treatment. So parents make serious medical decisions all the time on behalf of their children.
The Jehovah's Witness one's fascinating to me because in it we see you know, there's a lot to unpack with it, but the 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 notion that parents will only do what's best for their kids. I mean, we've seen this line, um, and I think generally speaking, it's true, but we've seen this line brought forward by Danielle Smith of today, not Danielle Smith of yesterday. Super weird. But we've seen this line brought forth by Danielle Smith of today, where parents will always do what's in what they believe is in the best interests of their kids. But Jehovah's Witness is a very fascinating example because a parent who is a Jehovah's Witness will refuse potentially a blood transfusion that is life-saving for their child because they believe that it violates their faith. So a parent will, in the name of their faith, on occasion, choose to let their child die preventably. That's a thing that happens. And there's, as you just said, there's court cases around that being a thing that happens. And this is the part that drives me absolutely bonkers about the whole conversation that we're going to have, is that everybody who is pro certain bills 26, 27, 29 takes the approach of parents would never ever do anything to hurt their children. And there is for sure an argument that most parents would act in what they believe to be the best interests of their children most of the time, but sometimes what they believe is wrong. It's not demonstrably in the best interests of their children on this ethereal plane. So that's an important piece that I think is, I love that example. I'm going to use that example. Thank you so much for that. Because it is like well-intentioned parents can still make really horrible mistakes. Um,
Yeah. Yeah, and so there are cases that use sometimes the language of a protected sphere of parental decision-making authority, whereby the courts give parents leeway. The parents don't always have to do exactly what the doctor is recommending, or if there are differing medical opinions, the parents can pick which one they're going to go with. So there is this sphere or room for leeway that parents have. But if what they're doing rises to the level of denying their child necessary medical treatment or neglect, that's where you can have child protective services become involved.
yeah, and we see people criminally charged as well. I mean, there's the failure to provide the necessities of life, I think, is
Yeah,
the piece that happens tragically.
yeah.
So that's just an interesting little thing to highlight, I thought. Um, but with the Bill of Rights, there's a couple of different pieces. So we got the vaccinations piece. The guns piece is weird to me because it's like, hey, everybody, the laws are the laws. Yay. And that's all
Yeah.
that it seems to have in regards to any sort of weight or force. Am I missing something? Is there something new with the gun thing, or is it just like, yeah, we like guns and laws are good?
Well, I think ultimately a lot of these things, there's nothing new to. I mean, even sorry to go backwards, but even the medical piece, we already have a right to be free from coercive medical treatments that's implied by Section 7 of the Charter. You have the right to life, liberty, and security of the person. There are a ton of medical cases. There's also cases where doctors provided patients with care involuntarily and they were sued in battery. So those aren't really new rights either. You already and of course during COVID, the government took a provision out of the Public Health Act that would have given them the authority in a public health emergency to vaccinate people. So we already had vaccination freedoms. The gun stuff similarly isn't really new either. And we heard the premier say that a lot of the gun regulation does fall to the federal government under the criminal law power. But she did say that, there were areas where the regulation of firearms could fall within the provincial power, constitutional power of property and civil rights. And so, perhaps what they're saying here is as a nod to the members of their voting base who find these issues important, is that we can't necessarily control what the federal government does, but we, the province, aren't going to place restrictions on firearms under our property and civil rights power that go beyond what exists in the law currently. But again, I mean, I think all of this is mainly just pandering to members of their political base. We have people who do want broader gun rights or who don't like the way the federal government regulates guns. We have people who were mad about how COVID was managed. And so in some ways, this is just a nod to those people or a pandering to those people rather than it is creating actual new legal rights.
What do you make of the freedom of speech expression stuff? Because I know that there were a lot of people that were deeply, deeply saddened and troubled by the fact that the college in Alberta went after Jordan Peterson and he was sanctioned by the college in Alberta. I'm being
Yeah.
wildly facetious here because that's not a thing that happened.
Yeah. So, in some ways, the speech and expression piece makes sense because it aligns with the charter, and so to the extent that the courts might borrow from the charter case law to interpret the Alberta Bill of Rights, that wording does make sense in some respects because the charter is broader than just speech and includes expression. But in terms of what expression includes, there are some interesting cases that make that kind of argument. So, for example, there was an argument that being forced to wear masks limits your ability to express yourself in the manner that you would choose to. So, that's an interesting example where expression specifically rather than speech came up. Um, with respect to the colleges piece, I think that's something that's still getting unpacked. But it sounds like what the premier wants to do is to limit the ability of the professional regulatory colleges to limit the speech or expression of their members. And so again, I think this is largely a response to COVID. During COVID, you had doctors, small fringe minority of doctors who were opposed to vaccines or who promoted cures, quote unquote cures, that weren't evidence-based or treatments that weren't evidence-based. You also had other health professionals, like there were instances of chiropractors promoting adjustments as boosting your immune system and helping you be immune to COVID. And so there were instances where the professional self-regulatory bodies actually uh, went through disciplinary processes to prevent their members from making these kinds of statements. And so what the government seems to be seeking to do is to allow this kind of speech in the future. And right now they're in the phase of some consultation on this issue, and it isn't clear exactly what they're going to do in this space. But the concern, course, is that the professional self-regulatory bodies, their mandate is to protect the public. And if you have a doctor making anti-vax claims and you have people, and that doctor's active on social media, or that doctor has a large following, or that doctor is invited to speak at gatherings, that person is more credible than is just some random person on the internet making anti-vax claims, because that person is making those claims in conjunction with the word doctor, the title doctor. And so I don't know that the colleges can adequately protect the public, which is their mandate, if they can't prevent instances where their members are spreading anti-science, anti-public health views to the public.
Yeah, I mean, on that, it's fascinating to me that there are physicians, air quoting for the audio audience, out there who may or may not have the right to practice. And the there are, and this is it's nuanced, and I want to get your thoughts on this, but there are sort of gradients to how far you can go with freedom of expression. I think when you're operating inside of the professional realm, if I was to, I'll use myself as an example. If I was to say as a paramedic, hey, if somebody has this injury, then you should um, get some basil and treat them with basil. They'll be fine. If it's a stroke, just give them basil. If it's a heart attack, just give them basil. I would be, I feel like, well within my rights, especially if I was to say that on a public platform. My college would have every reason to come after me and say that I was being negligent because basil doesn't cure heart attacks or strokes. And to be clear, basil doesn't cure heart attacks and strokes. Please don't do that. Um, so there's that piece where if you're saying something that contradicts the available evidence in whatever field you're practicing in, you need to be held responsible for that if you're holding yourself up as somebody that people should listen to. But as a further example, there are still limitations on the freedom of expression that exist. I'm going to invent a hypothetical situation that definitely didn't happen last week, where a certain former physician may have showed up on the breakdown social media and started to say that everybody involved with the breakdown was pedophiles. Um, Demonstrably false. We responded simply by saying, well, that's demonstrably false. And if you don't delete it, then you'll hear from our lawyers.
Yeah.
It was deleted. Weird that. Um, but there are limitations to, like, you can say whatever you want, but you also get consequences if you go too far. And that exists in all frames. So the notion that if you're acting in a professional regulated body capacity, that regulatory body should be able to say, whoa, 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 you're stepping outside the lines, or whoa, 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 you're lying to people. That doesn't seem unreasonable to me. Is there a part of the argument that I'm missing?
No, I mean, look, are there cases where the professional regulators have ever gone too far? Absolutely. And we heard a couple of these examples from the premier. And one of the examples she had given was a nurse who had criticized some of the care that had been given to her mother. And in that case, she wasn't making claims about medical treatments or nursing practices or these sorts of things, but rather, the quality of care in a particular facility and sort of things that had gone on in that facility. And so I think arguably the college in that case maybe did go too far, and indeed, she was vindicated in that case. And so are there cases where the colleges have ever gone too far? Yes, but we already have recourse in those cases. In those cases, those individuals can appeal those decisions of the professional regulatory bodies to the courts, who are acting as a check on when those bodies go too far. And so I think that that having the courts as a check on those professional regulatory decisions is completely appropriate, and the courts can weigh in on whether or not what the person said was done in her case, in her capacity as a nurse, and people would interpret it as, general advice or opinions on nursing, or whether it was done as a commentary on care that a family member had received. And I think that that's an appropriate response for the courts to be the check on the colleges. What I don't think we should do is this knee-jerk reaction of just taking away the ability of the colleges to deal with members who say things that are anti-science. And so I think that the kind of classic example would be a physician who is sharing anti-vax views. That clearly engages the public safety. They're doing it in conjunction with their title doctors. So they're trying to give credibility to their anti-vax claims. It's not a, I in my personal life did or didn't get vaccinated kind of thing. It's a they're putting out those views and intending to influence the public to, in that case, not get vaccinated. So I think that the colleges are generally do a good job of not overzealously regulating the speech of their members, but in the rare instance when they do, the courts act as a check.
Is this part of a greater there's been a lot of commentary that's gone on around sort of the erosion of expertise. And
Yeah.
I wonder if this is like looking at the fire that is the erosion of expertise and going, well, but what if we threw gasoline on it? Because to me, if we say that any paramedic can go out and say, "Oh, they lost a leg. You know what you should do? Put some basil on it." If that's the logic that we're going with, then I don't know what the consequences would be for me as a paramedic if I told somebody, "No, no, go and put some basil on it." I read about it on the internet. This Billy told me to that it would work. So I have whatever. And then that person dies. And I don't know what sort of consequences there are if I say dumb shit and somebody follows it. And if you take away the ability of professional associations to regulate that, then um, to me, it seems like you could have a bunch of people saying a bunch of really, really dumb things with no fear of consequence.
Yeah. Yeah, I do think we are seeing an erosion of expertise under the current government, but even even as well under the premier the previous Kenny government, where there was a turning away from experts. We saw a number of fairly high profile pieces of health legislation introduced, and experts say, we weren't consulted. It- We've seen this most recently with some of the legislation that we'll talk about later, dealing with gender affirming healthcare and the relevant professional bodies saying we weren't ever consulted. I think we saw more so under the previous government. We saw an actual bullying of experts to try to silence them and not get them to comment publicly on issues, and that a lot of that took place on Twitter. And so I think there is a turning away from expertise. Or, if we look at this reorganization of the entire healthcare system, that isn't done in response to expert consultations or evidence from other jurisdictions. That's just let's do this and see what happens. They've never offered up any kind of rationale that is based on expert evidence or other jurisdictions or reports or any of these things. And that seems to be the case with a lot of their policies. And so similarly, I'm not surprised that they're eroding some of the freedom of the self-regulated professions to govern their members. I think we've seen it in more minor ways in the past. So, for example, under the previous government, the percentage of members of the College of Physicians and Surgeons and other health professional colleges that are appointed by the government is higher than it used to be. We also saw Minister Shandro issue a directive to the College of Physicians and Surgeons to tighten up their policies around doctors leaving the province. So I think we have seen small moves towards greater control over the regulatory colleges than maybe was the case in the past. And I think this is a further step in that direction, and perhaps a bigger and more important step.
I'm curious as you were speaking there. I mean, yeah, there's no question that the Kenny era saw the attempted intimidation of contrarian voices. Um, there's no question that there was definitely the bullying that occurred there. Hey, Matt, um, which one's worse? Because, like, on one hand, if you're saying, oh, we don't want those experts to use their expertise and say the expert stuff because that might invalidate our position, and we don't want that, that seems really bad. But to say, or I just don't want to hear from the experts at all. I don't care what they say. They can say whatever they want. I just don't care. That seems
Yeah.
also really bad.
Yeah, I mean both are bad, and in the one case, trying to silence the experts, and trying to silence people from commenting on government policy and law, that's obviously anti-democratic. Democracy demands sort of open dialogue around laws and policies, and so on the one hand, it's kind of offensive on a very principled level to be doing things that squelch democracy. On the other hand, the policies of this government are arguably worse because yeah, I mean they go further, and they simply don't seem to care a lot about what experts are saying. And so both are bad, but I suppose, if I had to pick between the current government or the previous government, in many ways, the current government has managed to make the previous government look somewhat reasonable in some instances. And so if we use the vaccines as an example, the current government, the only thing they ever say about vaccines really is, stuff around coercion, and we won't make you get vaccinated, and all of these things. At least the previous government encouraged vaccinations. They did talk about how you had the freedom not to do it, but at least they encouraged people to do it. I think it's astonishing that the current government, how little we've heard from them encouraging people to get vaccinated this flu season.
Yeah, they do fold themselves into all kinds of fun shapes to avoid saying the C word. And the vaccination word. Um, I want to start to get into um the Bill 26, Bill 27, Bill 29.
Mhm.
And I hate, for the record, that we have to talk about these things. Um, it is Janice Irwin did her member statement in the legislature last week, where she talked about, hey, this is really bad for a whole list of reasons, and Danielle Smith knows them because she read them into the legislative record not 10 years ago. Um, and then 2 years prior. So, like, there's no, not in the legislature 2 years prior, but there's there's no question that Danielle Smith should have, what are the words I'm looking for here? Ah, yes, the competency and capacity to recognize that the positions that she's taken are in wild contradiction to positions that she's held before. Nonetheless, she's pursuing them. But there's two pieces that I want to kind of play with you here today, if we can. One of them is the arguments that Smith is using to justify them, because I just want to hit my head on things when she does. But the other piece is the actual legislation, and that's really where I want to spend the most time because I think that's where uh, people need to hear the realities of the legislation more than anything. So let's work our way through the very bad things. Bill 26, the Health Statutes Amendment Act. This is, unless I'm mistaken, the legislation that prescribes to physicians, despite the evidence, despite their medical expertise, they will not be allowed to provide any care, any medical care for people suffering from gender dysphoria at certain ages. And some of them are things that just don't happen. And again, I can't believe I have to say this, but for the Twitterati, there's no bottom surgery that's done in Canada under the age of 18. Just stop it. Um, what are your talk about Bill 26 before I
Yeah.
want to rant?
Yeah, so I mean, Bill 26 is actually really long, and a lot of it is pretty innocuous, and it deals with some of the restructuring, and kind of renaming things due to the restructuring, and so there's a lot of just kind of more boring, mundane stuff that's in Bill 26, kind of housekeeping amendments, but the interesting and concerning part of Bill 26 really limits the ability of medical professionals to provide gender affirming care. And specifically, it deals with two things. One, it deals with a whole list, and it actually enumerates them, of different surgeries. And as you noted, there were those surgeries that just weren't being performed. And I have to tip my hat to the media when this legislation was announced for pushing back on the government and saying how many of these surgeries are actually happening in the province. And it became clear that bottom surgeries, zero, top surgeries, small numbers. And it wasn't even clear that all of those were for gender affirming reasons, as opposed to other reasons. And so, yeah, I think that's interesting. It seems to me that when you're legislating something that isn't even happening, you're doing it to score political points and not to address an actual problem. So the legislation talks about how this list of surgeries can't be performed on minors, um, and as we talked about before, this is interesting because in other areas of medical care, minors can make decisions on their own behalf, as long as they have capacity. The only other medical service that's restricted to people to that age of majority is medical assistance in dying. So those are really two kind of peculiar examples. The other thing that the legislation does, and this is actually contrary to what was announced when the government talked about the legislation. When the government talked about the legislation, they said that it would be under 16 couldn't be prescribed medications. And actually what the bill does is it puts that age at 18 as well. So somewhere in the mix, we went from you can start getting medication at age 16, and that became age age 18. Although it does say that the minister can, by ministerial order, grant exceptions. So perhaps there's an intent to grant an exception for 16 and 17-year olds. But interestingly, the legislation doesn't only prohibit things like giving people hormones that are gender affirming hormones. It also prohibits puberty blockers, which has come under some criticism, because for some that isn't making these kind of permanent life altering sort of things that we've heard the government talk about. In some ways that just buys time for that minor to make the decision later on. And so in some ways you think the government would actually be in favor of using puberty blockers because they buy time, and that person could reach the age of maturity while on those puberty blockers, if the government is so concerned about people not receiving that gender affirming care until they reach the age of majority. So that's a strange one to me.
I mean, there's a lot to unpack there. One of the things that has come up is the question of the ministerial orders, because the one of the concerns that has been raised, and I think is valid, is the if the legislation is in force on proclamation, then how quickly do those ministerial orders come gets to be a really important part of the conversation, because if LaGrange has a sick day, um, then there could, and it sounds ridiculous, but unless I'm wrong, there could be a period of time between the proclamation of that law and those ministerial orders being issued where it would be illegal for physicians to continue to provide care for people who are already receiving care, because it's under those ministerial orders that those exemptions are going to be provided. Um, that
Yeah.
seems kind of bonkers to me. Am I wrong?
Yeah, we don't know what will happen, and people who are currently receiving care are justifiably worried about what kind of continuity of care there will be. I mean, if they'll get exceptions, ministerial orders, exceptions at all. And this similar argument unfolded in Ontario many years ago, not with minors, but with adults, and around the government's payment of gender affirming care. And that case was litigated before a human rights tribunal, who actually did say to the government, well, we're not going to make you pay for these services generally, but you are going to pay for them for the people who have already started down this long path that at the time was required to access this care. And so I think that the people here are justifiably worried about that kind of continuity of care and what will happen.
It's I mean, you talked a bit about how the puberty blockers, um, I mean, really, they just press pause. This is something that the AMA, when we're going to talk about that in a bit,
Mhm.
that the AMA had to issue a statement on. But it's wild to me that the argument that Smith and Co. have retreated to is, oh yeah, but puberty blockers, man, it's like marijuana. They're like gateway drugs. Once you get started on them, then you move on to the hard stuff. And there's not great evidence for that, but that's the argument that they're using to try to say this is why we have to stop the puberty blockers. What are the legal implications of that? Like,
Yeah.
are they allowed to say, well, we have no evidence for a thing, but we're afraid of the boogeyman, so we're going to like take away people's access to healthcare? Are they like, what are the legal
Yeah.
implications there?
Well, we could see people making charter arguments, and saying that the government limiting their ability to access certain forms of healthcare limits the right to, in particular, security of the person. And we've seen cases like that before, right? The way that medical assistance in dying became legal in Canada was that people said that the government barring us from accessing medical assistance in dying violates our right to life and security of the person. Similarly, with abortion, historically, there was this onerous approval process to get an abortion, and people made the argument that the government's barriers to them accessing that service violated their right to security of the person. And so there are cases where people have said that government barriers to accessing care do limit those rights to life, liberty, and security of the person. And if a court found that, it would then turn to the government to have to justify that legislation. And it isn't clear to me what justification a government would offer here, because while they're making this gateway argument, I haven't seen professionals backing that up, and quite the opposite. We've seen authoritative professional bodies making the opposite sort of claim. And you'll hear the courts talk in many charter cases about, if you are going to limit individual rights, you have to do so as minimally as possible. And where you can carve out exceptions, you need to carve out exceptions. And so I think at the very least, there'd be a great argument to be made that, even if the rest of this is going to stand up, you should have that carve out for hormone blockers, or for puberty blockers, sorry.
Is there a Section 15 component as well? Because like for them to say, hey, you know what, the top surgery or the mastectomies or breast reductions, those are not allowed for people who are being any kind of gender dysphoria or any
Mhm.
sex reassignment. Now, when I read through the proposed legislation, it appears that if I'm a 15-year-old guy and I've got some gynecomastia going on, um, think Fight Club Meatloaf, then I can still access that treatment. So it does seem like there is an inequality before the law in regards to accessing the treatment there. Am I off base with that? Am I just clutching?
No, no, for the listeners, Section 15 limits the ability of the government to discriminate on the basis of a whole bunch of different things, including sex, gender, etc. And so I think that we might see an argument where allowing a particular surgery for particular medical conditions, but not others, is discriminatory. And so as you say, certain surgeries, if they're able to be done to treat cancer or for gynecomastia or for those kinds of reasons, then denying them to other people for reasons that those people argue are medically necessary, their doctors might argue are medically necessary. We might see that also result in a Section 15 claim. And again, the government would have to produce evidence. And so there are cases like this that we've seen in the past. So for example, there was a BC case around the age for prostate cancer screening, and someone argued that it was discriminatory that men didn't get screening funded until they were a certain age, whereas women had cervical cancer screening funded much sooner. And in that case, the court unpacked the reasons and said, well, it makes sense because the risk for women of cervical cancer shows up sooner, and the government had evidence for the ages that they had set. Here, it's not clear what evidence the government would bring. And so they would have to justify why they've made those cutoffs that certain people can get certain surgeries and other people can't get the same surgeries for different medical conditions. So, whenever you have laws that are drawing those kinds of distinctions, they invite potential Section 15 arguments.
So I'm not wrong.
No, not at all. I think, and especially when people are litigating new issues, you want to kind of throw all the potential arguments you might make out there to see. You never know what's going to stick with a court.
There we go. Okay. Anything else about Bill 26, the Health Statutes Amendment Act, that you want to sort of highlight before we move on to the other two dumpster fires?
No, I think those are the main things, is just watching and waiting to see what those ministerial orders will look like. And then I think, of course, the other interesting thing is just watching how this continues to play out, the dialogue between the governments and some of the professional bodies, and not just professional bodies. We're also hearing a lot from other stakeholder groups that are affected by this legislation.
I'm going to ask you about the consultation stuff, and there's another piece in there that I was like, oh, I think I might see what you're doing there. Well, let's move on to Bill 27, the Education Amendment. Actually, before we do, I wanted to ask you a question, because you talked about, I mean, the Health Statutes Amendment Act, Bill 26, is long. It's like 80 some odd pages.
Yeah.
And the vast majority of that seems to be, we're going to call them not health boards anymore. We're going to call them health corporations. Is that
Yeah.
just like boring paper thingers, or is that something people should actually be paying attention to?
No, it's pretty mundane. It seems like that's the language they're going to be using to describe these new organizations that are going to be dealing with the four spheres of the healthcare system. And so while that reform of the healthcare system and siloing into four different spheres is problematic, and I worry about people falling between the cracks, and I worry about a lot of wasted money and time on administration and new policies and procedures as opposed to providing medical care. So I think we have 8,001 reasons to be worried about those reforms. Right now, the kind of name change is really just to reflect how the government is going to refer to them. So
Okay.
the problem is in the reform itself and how it's going to play out, rather than, as you say, most of the pages were just going through all of the statutes that made reference to health boards and changing it to corporations. And there are a whole lot of statutes that make just one or two mentions and in passing, like the Privacy Act, for example, or Health Information Act. So a lot of it is pretty mundane.
Yeah, when I first opened it, I was like, okay, let's take a look. And I was like, whoa, 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 whoa. Why is this so big? And then it was just, and we'll change this to this and this to this and
Right.
this to this. So the
And
education.
actually, and actually, that was a lot of that was probably overdue. Like if you read old pieces of legislation, in well, really many pieces of legislation in this province, they still talk about as though there are multiple regional health authorities, even though we've had a single AHS for a long time now. They still make mention of the multiple regional health authorities that in plural that used to exist. So in some ways, it was actually a bit overdue to make some of those changes.
Education Amendment Act. So much going on here. We have the parental notification. We have the more parental notification. We have the sex ed stuff. Um, the parental notification stuff to me is pretty wild, because the way that the legislation is written, it says if there's any reason to believe that the kid is not comfortable telling their parents, then we'll get counselors involved. We're still totally going to out them, but we'll get some counselors involved. And to
Yeah.
me, I mean, it would be implied if the kid is coming to school and saying, I don't want you to tell my parents, or I'm telling my school before I'm telling my parents, it seems to me that it's kind of implied that the kid is not comfortable having the parents know. So I'm wondering, where are these various different school boards, especially some of the smaller ones, going to find this army of appropriately trained psychologists and counselors to prepare the kid for all of the deeply horrifying things. But before I start to pin down certain things, what are your takeaways from Bill 27?
I think that, my biggest concern is really with the notification stuff specifically. The sex ed is different. We can get to that, but the notification stuff, I think my main concern is really just the health and safety of the affected children. If there are children who don't want their parents to know, could we see potential domestic violence situations? Could we see suicides occur? That's my concern. Is that we might see those kinds of things happen as a result of notification? Because of course, you worry that a child isn't aware of these notification laws and so thinks that school is a safe space, thinks that they can disclose certain things at school, and has absolutely no idea that their parents are then going to be notified. And there may be good reason that they have chosen not to tell their parents.
There's two pieces of this argument that I think have kind of been lost a little bit. The first one is how unbelievably rare what we're talking about is. Like, for a kid to come to school and say, um, I am now identifying in this way with this name with this pronoun. That's not a thing that happens a whole lot. I mean, one
Yeah.
kid in a school does it, and the whole school goes, "Ooh," and everybody pays attention. But that's still one kid out of several thousand. So eh, it's not as big of a problem as it's being presented as. I mean, it's not a problem at all. I want to be really clear. Let me fix my language on that. But secondary to that, the notion that, again, I just go back to and I'm trying really hard not to insert myself in this conversation too much, but um, the notion that parents won't be horrifying is just
Yeah.
false. It's just false. There are the vast majority of parents, 100%, well-intentioned, love their kids, wouldn't do anything to hurt them. No questions there. But there are demonstrable examples. Danielle Smith herself read them into the legislature record of parents who beat their kids because they say, this is who I am. Uh, and so to just disregard that and say, oh, you know what we'll do? We'll hook you up with a school counselor and everything will be okay. And I don't know
Yeah.
if the field of school counseling has evolved in quantum leaps since I went to school, but we made fun of our school counselors back in the day. And I suspect, as well intentioned as they are, they don't come with a great deal of psychological training. So I'm not super sure that they're super prepared. Um, what is the legal, like? is there legal recourse here? Because it seems to me that if a kid goes to school and they say, I'd like to be known by this name now, then, and I don't want my parents to know because they're going to kick the shit out of me. They will kick me out of the house. My dad has said that if I ever do anything like this, that he's going to beat me to death. Please don't tell them. And then the legislation kicks in and says, but we have to tell them. It seems to me that there is a willful and deliberate putting that kid at risk of harm. And
Yeah.
is there liability for that?
So, I mean, arguably the legislation shouldn't have done this at all, but if it did, it ought to have had a carve out for situations where there is this, um, credible threat of to the child's health or safety. And in terms of what will happen in those cases where the child says, "I had no idea you were going to tell my parents," if you do, I'm concerned that this is going to happen. Um, One potential legal thing that we could see happen is we could, of course, see Child Protective Services engaged because schools have mandatory duties to report these kinds of risks, but it's not clear what their response will be and if they'll have an effective way of dealing with these kinds of cases. I think we might see litigation around the constitutionality of these provisions and and the risk they create to again potentially to life, liberty, and security of the person, those sorts of things. But all of that kind of takes time, and we don't know how that's going to roll out, and that doesn't really help. A child who might be facing this very real issue in not such a long amount of time. Um, and so it isn't clear how all of this is going to play out legally. As a school, even though the legislation authorizes me to tell the parents, I think that would be a difficult call to make, and I would be concerned about liability implications if the child was credibly saying that there's the threat of domestic violence at home. But if you have to tell the parents, your hands are really tied, and all you can do is, I suppose, notify Child Protective Services of this risk. But I worry about kids falling through between the cracks if that's the response.
Maybe I missed it. Um,
Yeah.
I hear that Child Protective Services is just wildly over resourced. They have no issues with
Yeah.
resourcing whatsoever. I mean,
Yeah.
um, has there been, to your awareness, any sort of increase in resources or budget with this legislation being rolled out, or did we just forget about that part too?
I'm not even sure that the government really necessarily entertained that link there. That the fact that schools would potentially have to report these threats of violence, and then those would have to be acted on. I'm not sure if they sort of considered that mechanism, because it didn't immediately occur to me either. It's just sort of when you start to kind of rack your brain. Okay, well, if there's a threat of violence at home, what happens in that case, and that's one of the potential mechanisms, because of course, you have the engagement of school counselors, but that's the other kind of obvious entity that might become involved. So I'm not sure that they entertain this, or whether they think it can be managed with existing resources.
Yeah, I'm gonna go with they didn't think it through. That's my speculation, only because there have been conversations around the GSA piece when that was a big conversation around if a teacher believes that a child is at risk, they have a legal obligation to report that to authorities, those authorities being the police or Child Protective Services. So they haven't taken that away. So if a teacher believes, like, it's cute that they threw in the we'll make sure there's counseling available. But that still does not eliminate the teacher's responsibility to report that child as being at risk. So,
Yeah.
um,
Well,
this,
and again, like, I really worry about the fact that children don't know this legislation exists. And so they're not in a position to weigh these things before potentially saying something at school. Like, this the fact that there is this threat of domestic violence might not even become known until the child has said something at school. The can of worms is open, the school's hands are tied. They really don't have an ability to make an informed decision, because they may opt to not say something at school if they're aware this exists. But I mean, I'm going to go out on a limb and assume that children aren't closely following the going-ons in the Legislative Assembly.
You're probably right about that. Um, but that to me brings in another piece of it is, if there are kids that are aware of this legislation, then what this forces, in effect, is, Danielle Smith and the UCP have said, you know what, if a kid is asking their teachers to use a different name or different pronouns, then the parents have a right. I just chafe at that. A right to know about it. I would argue, no, they don't. But if the kid knows, that's that's almost worse in a way, because
Yeah,
if the kid knows that if they go to their teacher in the school that is supposed to be a safe place and they say, "Hey, I'm struggling with some things. I'd really like it if you referred to me as whatever. I don't care." Um, that their parents are going to be immediately notified.
yeah,
There is unquestionably a chilling effect where there are going to be some kids who just eat it. They just have to eat it until they're 18 and they're able to get out of those homes. And those homes are real. I mean, like the suicide rates for LGBTQ2S plus youth are ridiculously high. The suicide rates for trans kids are even higher. And I have been hammering on this point ever since the study was released. But the reality that in areas where this sort of legislation is introduced for trans kids, you see an up to 72% increase in suicide. Um, that is just like, for me, I'll put it this way, and then I'll give it back to you. For me, like, these are the people who lose their minds over the 0.0001% of a time that a vaccine causes a blood clot, or has some sort of other negative effect. But when it's 72% increase in suicide for kids, they're willing to go, that's fine. Like, that just, to
yeah,
me, it's so dissonant. Um,
yeah.
can't wrap my head around it.
Well, I think you're absolutely right about the chilling effect. I mean, not only can the child not say to the teacher, this is how I want to be addressed. They also can't use the school as a way of getting at other resources. So, we talked about school counselors before. They also can't access, via the school counselor, any other resources that might be helpful to them. And so, they can't access healthcare services. They can't gender affirming healthcare services. They can't, get access resources through school without their parents being notified. I mean, the walls must really start to feel like they're closing in around what options you have available. And so I think the effects on these affected kids are just so unfortunate. And I just it's just so angering that the government is allowing that to happen in order to make these cheap political gains. And especially when there are, so many actual problems right now that the government could be turning its mind to. It's wasting its time on these issues. But unfortunately, based on what went on over the weekend at the UCP's annual general meeting, it seems like many of the members of the party are eating up what the premier is serving, and they think that all of this is great. And actually some of them would go even further than she's been willing to go. So it's just so discouraging. But I, and the premier has seemed to do what Jason Kenney couldn't, which is pander to both the extreme members of the party, but also some of the more moderate members of the party. He fell short on doing that during COVID, but Premier Smith seems to somehow be navigating that and pulling in some of the more extreme members of the party with some of this legislation.
I wonder if she's going to be able to continue to thread that needle. And here's the reason why. Um, the policies that were passed, I mean, everybody can go, 91.5% sounds like a good radio station or something, whatever. I don't care. They can take that victory lap if they want. But to me, the ongoing conversation that's going to occur in the province of Alberta around the UCP AGM is that this is who you are now, because these are all of the batshit crazy policies. And like, it's not that I'm being mean. It's the policies that they voted for as a party, that define themselves as a party, are now saying any gender affirming care needs to be considered under the realm of cosmetic surgery, and that anybody who accesses that has to pay entirely on their own. Their party endorsed that policy. Their party endorsed the policy of only women at conception, and I understand there's some sciency problems around that statement, um, are allowed to use female spaces as such as washrooms. Um, which, I mean, I guess the leopard ate your face. Some of the folks who stood up to defend Smith's policies, um, the CO2 stuff. Like, this is not Jason Kenney. At least took the line of, well, I hold the pen, and a lot of people didn't like that because he said, I've got the power. Um, but Danielle Smith has not offered any of that. And so I
Yeah.
think that one of the things that conservatives in this province are going to have to reconcile is this really who you are? Is this who you want to be counted with? Because it went way farther than I think any other jurisdiction, any other mainstream political party has ever gone in the country. And it was every single, like, it blows my mind that every single one of those policies was approved. Because I wasn't allowed to be there. They don't like me. But I asked, and we had some people in the room because we have some friends, and I was like, okay, so what passed, what didn't? And the
Yeah.
response I got from everybody was like, oh, no, they all passed. And it was like, no, 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 that's not possible. So I don't know how well she's going to be able to thread that needle on a long-term basis, because I think there's a lot of small C conservatives who would have considered themselves the progressive conservative part of the UCP, who are going to be looking at how this party has chosen to define itself and go, oh, wait.
Yeah. Yeah, I mean that's a good point. How far can you keep pushing this towards the more extreme policies before those people more in the middle say no thanks? I would have thought this would have done it. And of course we're seeing this play out in the US as well. I just watched an interview this morning with some previous Republican supporters who, due to Roe v. Wade, aren't voting Republican in the next election. And so, there are people who will pull out on principle, but then there are people who will keep voting with the Conservative Party, or the UCP, even if they think they're going too far, just because that's how they've always voted. So, one wonders though, if she pushes this too far, will we see another fractioning of the Conservative Party?
So that seems to be what they do. Um, the other piece is the sex ed piece, and I want to spend some time on that
Yeah,
because
yeah,
it seems like a very bad idea. And I mean, Danielle Smith has equated it falsely to being just like a field trip.
yeah,
But my understanding of the legislation is that this handcuffs teachers to talking about anything to do with sexual health or gender or identity, unless they have approval 30 days in advance from the minister, who
yeah.
has a long history of working with pro-life organizations. So cool. Um, what do you make of that part?
Well, anything that erodes access to sexual health kind of education. We've seen this play out in other jurisdictions, and it's problematic in terms of things like teen pregnancies or sexually transmitted infections. I mean, the consent. These are important topics that you need to know as a functioning adult, just like the various other things that people learn in school. And so, to me, um, treating them differently and having parents have to sign off on them and all of these things is really just another attempt to score cheap political points. Uh, having parents have to opt in and these sorts of things. People, even parents who want their children to receive this education, might mess up the permission slips or the opt-ins or whatever the case may be, and sort of setting up people to accidentally not receive this education is problematic. And then, of course, allowing people to opt out. My concern is that the people who would opt out are the people whose kids probably need this education the most, because they're probably not getting it at home either. And so if when we erode this education or access to this education, I do worry that we're going to see teen pregnancy rates go up, that we're going to see sexually transmitted infection rates go up, all of these sorts of things.
Do you think that these policies are an abdication of parental responsibility? And I say this because to me, I got two kids. They're both pubertying. It's delightful. And to me, the responsibility for me as a parent is to have these conversations with my kids so that they are comfortable, knowing that if they encounter something different, if they encounter something that we haven't talked about, then
Yeah.
they have the comfortability to be able to say, "Hey, Dad, there's this person who's using this pronoun, and there's letters in there that don't work the way that I thought letters work. What's going on here?" Um, and it's my responsibility as a parent to make sure that they have that level of comfort when they encounter things that we haven't covered, that they're comfortable coming back and talking to me. And what this change seems to do is to say, hey, you know what, parents, you don't have to worry about those awkward conversations anymore, because you can just put your little kid, Timmy, in bubble wrap, and nothing's ever going to encroach that bubble wrap until he gets a classmate pregnant at 16, and whoops. Um, i- is there an element of that abdication of parental responsibility there, do you think?
Yeah. So I think in an ideal world, parents are the ones who start these conversations with their kids, and then they're reinforced in school, or they're given additional information in school, and you sort of build the sexual health education over time. And it's sort of mutually reinforced between parents and school. That's an ideal scenario. I think under the kind of current system, what's happening is parents who aren't having that conversation are still getting it at school, and so they're not completely falling through the cracks. But yeah, I mean, I think absolutely this opens up the risk of kids to just completely fall through the cracks, because they're neither getting it at home nor at school. And what they're maybe getting is some secondhand, not so factual information from online or from their peers, or maybe nothing at all, depending on their situation. So yeah, I worry that we will see kids that just have this blank knowledge of what's an important issue, and is important information to have as a functioning adult in society. And so there will be kids that just don't get any of that information, or who only pick up some information of dubious quality. And you see it. You see kids, especially in American jurisdictions where they may not have received sexual health education, or they receive kind of abstinence only education, and you see them saying things online that just are not true. Not understanding how conception works, or all of those things, or the timing of things, or the kinds of activities that can lead to pregnancy. Just complete misunderstanding of reproductive health issues. I see it online all the time, and so I worry that this is just going to create more of those people in this province.
Yeah, I mean, as you're speaking of the two things that popped into my head were like, oh yeah, the other kids, because there's nothing in this that addresses like if you're the one kid or the two kids that don't go to sex ed class and you're friends with some of the kids that do, if you don't think that there's going to be some conversation that occurs there, holy hell, you're fooling yourself. But it,
But the problem is, it's like then it's the game of telephone, right?
yeah,
Then instead of
yes.
hearing it directly from the teacher in the way that it's intended to be presented, you're sort of hearing the game of telephone version that may not be entirely accurate from your peers.
And I also think it's important to highlight that there are, you're talking about the people in the States who don't know the things of sexual health. And it's fascinating to me how many of them are A, Republicans and B, in the Senate, because we have seen senators and elected officials throw out those lines like, oh, well, if it's an unwanted pregnancy, a woman's body can reject it. Uh, and that's the kind of bullshit that gets circulated out there. And especially a lot of the conversations that we're seeing coming out of the States in regards to Roe v. Wade. Uh, wow. There are some people who need to crack a book.
Yeah.
Um, the Fairness and Safety in Sports Act, Bill 29. This is another one where like I go, what problem are we solving here? And the communication strategy of the UCP seems to be craven. We saw Chantel Zhang in the legislature talking about, oh, there's all these young women who aren't doing sports anymore, and we have to make sure they know they can. And I'm going to go out on a limb and say that the reasons why we're seeing drop offs of young people doing organized sports has more to do with, I don't know, time and the costs of doing those sports than it does with, I might run into a trans person. Um, but I say that as a middle-aged white guy, so what do I know? But what are your
No, I mean, I think it's fair to imagine that the reasons that we see either a drop off or fewer than we would like girls engaged in sports is multifaceted. But I think you're correct in that the risk that they might run into a trans participant is not even on many people's radar, right? Especially if we're talking about, a lot of people who are in organized sports start when they're quite young. That issue wouldn't even be something that occurs to them. A lot of kids are starting things like hockey at 6, 7, 8, whatever years old. It's not even going to occur to them. That's not even going to be a thing that they would entertain unless their parents have sort of put that idea there. I mean, I think ultimately a lot of this is um, solving a problem that doesn't exist, and because it's such small numbers, right? When the government was pressed on how many people are receiving gender affirming surgeries who are minors, it's negligible. How many people in schools are showing up and saying, I want these other pronouns? Small numbers. How many people are we seeing in sports? Small numbers. And those small numbers of people are really being made the scapegoats of the government's desire to score political points with those extreme fringes of their party.
And again, I think going back to the point I made about the budget with Child Protective Services, if this was not that, if this was not just pandering, then we would see budgetary increases to make sure that there was greater accessibility to mental health supports and counseling. If we really believed, oh, kids are just confused, then one would think, if we're concerned enough about this issue, that we would make sure that there are supports to help them unconfuse. And we
Yeah.
haven't seen that. Those there's been no announcements of, and now we're going to make sure that there's a social worker or a psychologist
Yeah.
in every school.
Well, and that's one of I mean, regardless of whether, we think they're confused or what the government thinks or what other people think, that's an unfortunate absence in this piece of legislation is, we've heard a lot about how we're going to deny you healthcare, we're going to rat you out to your parents and potentially put you in a dangerous situation, we're going to limit your ability to participate in sports. And then of course, if the government brings in some of the resolutions that were passed over the weekend, we're going to, limit you from doing other things as well. There's nothing on the other side of the equation, like how we're actually going to give you resources and help you, apart from the sort of school counselor helping you be ratted out to your parents' business. There's nothing. We've heard nothing in terms of what resources are going to be available to young people who are maybe struggling with some of these issues, or who need resources, or who need help. And as we know, not just in the context of minors, but just generally speaking, it is difficult to access mental health services. It's difficult financially because not all of them are paid for. And then even within the realm of what's publicly paid for, there can be long waits, especially for people who are in some cases in an emergency situation. It's reached a point of crisis. So, the government really needed to deal with the other side of the equation, not just what are we going to do to you, but what are we going to do for you to help you sort through some of these issues.
And I think it's also telling a little bit, when Danielle Smith released the timeshare video from hell, as we've referred to it on the show, um, she made a lot of promises in regards to care for adults. There has been no word, no movement on any of those promises. So it's almost as if she was trying to say, hey, we're going to punch down on the kids, but if they could just make it to 18, we're going to have all of these wonderful resources available for them. Um, and none of those resources have been talked about. None of those resources have been materialized. There's been no mention of them at any of these press conferences. So I feel like at a certain point, what are we doing here?
Yeah, yeah, no, not I haven't heard anything about what's become of these resources. I mean, I suppose one bright spot, if we are to try to find a bright spot, is at least the health legislation only limits young people experiencing these issues from getting surgeries or medication. It doesn't prohibit their ability to see counselors, or to see, not school counselors, because then you run into the sort of tattletale part of the legislation. But it doesn't limit their ability to sort of speak to doctors about these issues, or to receive other kinds of healthcare services in conjunction with these issues. And if they're minors and they meet the test for capacity, those kinds of conversations and that kind of healthcare can be sought. Surgery and drugs aren't allowed, but at least there is an ability to talk to health professionals about these issues, and potentially receive some services or resources without their parents necessarily finding out. So if we had to find a bright spot, it's that the government didn't also prohibit them from receiving mental health services, or from seeing a doctor with respect to these issues. But the resources have to be in place for that to be useful or accessible. But I don't envy the doctors who have to have those conversations where minors come to them with these issues, and it's, well, I can't offer you surgery, we can't do medication, your hands are sort of tied, and you just have to kind of sit tight till you're 18.
I'm curious. I have three other questions that I want to ask you, and then been very generous with your time. But is there, and I don't know what the rules are around this. Let's say that BC doesn't enact provisions like these things. What's to stop me as a parent from taking my kid to Golden? Or what's to stop a physician who wants to provide gender affirming care to youth in setting up a clinic in Invermere, where I can then go with my kid? Like, it's horrifying that this is the kind of contingency that we have to.
Yeah.
I want to be really clear about that. It's horrifying. But is there any mechanism to prevent a child and or youth and their family from going to a province that isn't trying to live in the early 1900s to access this care?
No, and people do go to different provinces to access different care. I think probably the most common example is some of the long waits for surgery. People will go and pay for it privately in another province. So you can. But what I worry about though is whether you would find a health professional on the other end who's willing to do this. And I think there's two reasons for that. I think one is if we're talking about something like medication, that's sort of an ongoing healthcare need. And I think that they would be, you'd have challenges because you'd have to go back to continually see that professional about that medication, which is different than say like you go to Quebec, Montreal to get your knee replacement done. That's very sort of episodic. They do your knee, they make sure you're okay, and then they never see you again. Where it's a healthcare need, like you're taking medication over the course of many years, either you'd have to go back or they'd have to come up with some way of managing your care in the longer term. So there's that challenge. And then I just wonder if how many doctors in other jurisdictions would want to be seen as kind of a hotspot for people to come from other provinces to seek gender affirming care. Maybe a doctor in a larger city would be comfortable with that, but sort of small town doctor just over the BC Alberta border, they might not want to be seen as the sort of place that people come from different provinces to get that kind of care. It might be difficult, and we saw that same kind of dynamic happen when the government made available medication to induce abortion. We did not see a lot of doctors pick that up and become prescribers, particularly in some of the smaller places, because they didn't want to be, the town doctor, especially in maybe smaller towns that lean more conservative, that is the abortion pill doctor. And so similarly, there may be doctors who don't want to be seen as the gender affirming care doctor of that small conservative town. But we might see people start to go to other jurisdictions potentially. But then it becomes a resource thing, and it's only accessible to certain kids and not others.
Wouldn't that only strengthen the argument for a Section 15 challenge?
Yeah, that's interesting. We haven't seen that kind of Section 15 argument made. There's not a case I can think of as an analogy, but there was a case on private healthcare that went to the Supreme Court of Canada called Jolie, and in that case, the court talked about this concern that having long wait lists in the public system and having limits on private options, which is basically what we're talking about here, limits on private options, that then only the truly wealthy can access care, because the point they were making was that you could only access it if you could, for example, go to the States and pay completely out of pocket. So it puts it out of reach. And so as part of their charter analysis, that argument of only the truly wealthy being able to access care kind of came into that Section 7 argument. So potentially, if we started to see some people going out of jurisdiction for this care and others being left behind, we could potentially see that creep into that kind of charter discussion.
The other legal area that I want to pick your brains on, because
Mhm.
I think that Danny might have stepped in it a little bit,
Sure.
is there was a question that came at the end of the press conference where Danielle Smith was asked about the consultation that she did um, in regards to a couple of different things. And one of them was it's been identified, it was apparently identified in the technical briefing that this legislation will impact Two Spirit, First Nations, and Indigenous youth as well. And the reporter asked, so who'd you consult with on that one, Danny? And Danielle Smith said, well, it only affects we don't have any say on what happens on the reservations. these laws wouldn't have any impact on what happens on the reservations. So you can see where I'm going next. But it was followed up with, okay, but you didn't answer the question. Who did you consult with? And Smith again responded with, we consulted with the people that we believed would work with us with the ones that we chose who would work with us in a constructive manner. And
Yeah.
so there's two pieces that I want to get your thoughts on. Piece number one is, so maybe there isn't a gender affirming care clinic set up in BC. Maybe there's one set up on a reservation in Alberta. Um,
Mhm.
it- is that a viable option? And then I'll ask you my second question.
Okay. That is a complicated legal can of worms. That is outside of my realm of expertise, but I'll say generally that there is a whole body of case law on how and when provincial laws apply on in First Nations communities. There are experts in Aboriginal and Indigenous law that's their life's work. So I won't do them the sort of disservice of weighing in, but certainly that's a complicated area that I think she's being a little bit cavalier about in just sort of saying it doesn't apply. I think that's an oversimplification of a very complicated legal issue. But certainly the argument is out there. There was at one point discussions of a private surgical facility opening on a reserve in BC. And, does BC's Health Insurance Act uh, prevent them from just charging people to jump the line was kind of a conversation that was happening at the time. So it's not as simple as she made it out to be, is the answer.
Well, I would be willing to speculate, and I'm going to have to get a name from you of somebody that I can bug for that question because I think it is an interesting question.
Yeah,
But I speculate that if she didn't go so far as to think about, oh, what happens if Child Protective Services gets triggered, she probably didn't go through the nuanced conversation around that piece. Here's the
yeah,
other question that I have. She came out and said that she consulted with the people that she chose who would be constructive.
yeah.
Does this turn into a duty to consult conversation?
Well, I mean, it's not clear when she said that. Like, was she talking about just the kind of indigenous piece with that question? Well, I think the duty to consult case law doesn't just allow you to consult with people that you think are constructive. That the duty is broader than that under the law. And I think just when we think about democracy in general, politicians shouldn't just seek out opinions from people that they think are constructive or they think who would agree with them. And I think that's a problem, not just with that piece of the legislation, but with all of this is, it's not clear who they consulted with because we're hearing from important stakeholders and expert groups who obviously weren't consulted. And so it isn't clear who actually was consulted. And I think that's a really a problem here. And hopefully, in the implementation of this, we hear more from those groups.
We have the list. We FOIP'd it.
Oh, did
Uh,
you?
we did. And so we have the list of everybody who was consulted from an organizational standpoint. Obviously, individuals with their own private information, a lot of that got
Yep.
redacted. But in regards to the organizations, the consultation process is wild because they identified we have to consult with the AMA. They're super totes going to be against this, but we have to do it. So we will invite them to the table. And that was the extent of the consultation. So again, I would argue it was an entirely bad faith conversation. Here's my
Yeah.
last question for you.
Okay.
And then I'll let you get back to your day. Um, do we need a college of politicians because we are seeing so much bad faith, unethical, dishonest um, behavior from the political class where they're just demonstrably lying. And I go to the example that we saw where Danielle Smith stood up and was like, she was asked about the puberty blockers, and her response was, "Well, we've got this opioid crisis because of the doctors, so we need a grown up." And the AMA had to rapid response issue a statement saying, "Wow, it's so much more complicated than that, and what you said isn't true, and puberty blockers don't cause sterility, and please stop lying." They didn't say the last part, but it was subtext. Um,
Yeah.
do we need, like, if the argument is you have to have professional bodies so that when people are acting in professional capacities, they aren't misleading people in harmful ways.
Mhm.
Do we need a college of politicians to keep these people from lying?
Well, I think we certainly need checks on what they're doing, and I don't think an election every 4 years is sort of an adequate check on what goes on. So then who does that work? We have people like auditors general, but this really is a lot for them to take on all of this. We have entities like privacy commissioners, who, when it's a privacy issue, can sort of comment on the government of the day. But really, what has happened as these claims have ramped up that the government is making that are or policies that are contrary to legislation is you have a lot of stakeholders and experts and others that are sort of trying to fill the gaps and get factual information to people. And I think it's a lot for people to do. And so, I guess another check on government power can sometimes be the courts, but litigation is time consuming and slow. So I think that, while the college model is of course better suited to people who are of a particular profession, and of course politicians come from all different places, so it's hard to kind of slot them into the college model, in the way that some professions are. I think the broader point of needing more checks and balances on the government is certainly a valid one, and one that we need to keep thinking about, as long as we have a government that maybe is acting more to further their political interests than to make policy that's evidence-based.
Yeah, because I just go back, like, again, I work as a paramedic,
Yeah.
and when you want to become a paramedic, as a practicing paramedic, you have to
Yeah.
register with the college. And so to me, I just kind of go, if somebody wants to pursue a career as a politician in the public spotlight, then there should be a regulatory body of some kind
Yeah.
that is able to say this is a profession. You're doing a job. You're leading the public, literally.
Yeah.
You can't
Yeah.
lie.
Yeah, no, and it'd be a tricky job for whatever body was doing that, because of course, um, how how bad does a policy have to be before it engages the activities of the college? And then the other thing is even if a policy isn't evidence-based, is it legitimate for a politician to put forth a policy that isn't evidence-based if it's what the majority of voters want? Do all policies need to be evidence-based if they reflect the will of the people? So that would be a regulatory college that I would not envy those who have to sit on and sort of come up with in the first place, because their job it would be infinitely more complicated than some of, let's say, the health professional regulatory colleges that are applying standards of practice and these sorts of things. So that one would be tricky. But I think the broader point of thinking about what kinds of checks and balances exist and should exist, and can we make existing ones more robust, is certainly an important conversation.
I don't even think it would need to go to the policies. I think if you could just say, like, you're not allowed to lie. There's the rule
Yeah.
for the not allowed to lie. And if you do lie, then you don't get to be a politician. If it becomes a pattern of behavior, I think that because I take your point on the will of the will of the people, but I fear that all too often the will of the people is crafted by
Yeah.
politicians who lie. So
Yeah.
maybe if they didn't lie, we could have a slightly more informed electorate.
Yeah.
Uh, I want to thank you so much for taking
Yeah.
the time to chat today. Is there anything else? I mean, we covered a lot. Is there anything else you want people to hear? Is there anything else you want to highlight about any of the legislation?
I
Uh,
think, yeah, I think just to say that, a lot is still, I think the legislation, it's a majority government, it's going to be passed largely as written, but there's still a lot that can happen in the implementation. And so people can still push for, as we talked about, counseling resources and whatnot to be made available. We can still push for those ministerial exceptions and to make sure that those, or ministerial orders, make sure those come in a timely manner. There is still work for the courts to do. For example, what is medical coercion? Is vaccine passports coercive or not? I think forced vaccines are, but are vaccine passports. So, there's still a lot that's left to be determined. And so there is still room for people to try to make an impact in terms of how bad all of this ends up being. And I think there's places where maybe it can be mitigated a little bit.
and there are legal challenges pending. I mean, Skippy Stone and Igal have both stepped forward and said, "Oh
Yeah,
no, we are going to be suing your asses."
yeah,
So people can give money to them. They should give money
yeah,
to them. That's good things to give them money. Um, Dr. Hardcastle, thank you so much for tolerating me today.
yeah. Thank
Um,
you for having me.
and you know what? I'm going to say you're probably going to hear from me again once the compassionate care nonsense
Yeah,
starts, because that's a whole other
yeah,
outside.
yeah. Well, that legislation I've heard rumors that may come after Christmas, so we'll see.
That's good, I guess, the longer it takes.
Yeah, yeah. Yes, that's right.
Awesome. Thank you again so much.
Yeah, have a good day.
And that's it for another episode of The Breakdown. As always, if you appreciate the kind of content that we're trying to produce here, we would love nothing more than if you thought about signing up to be one of our Patreon sponsors at www.patreon.com/thebreakdownab, where for just the price of a fancy cup of coffee a month, you can help us continue to produce this kind of content. Whether you're listening to the audio version of the podcast, in which case maybe leave a review and a rating, or whether you're watching it on one of our streaming platforms, we want to say a big thank you to everybody who is part of the Breakdown's audience. And as always, take care of each other and keep the conversation going.